doesn't mean much.
That is the application. What I had in mind, I would add the word humbly requests Mheshimiwa Speaker and this Honorable House, the Senate, a couple of days I had in mind up to Tuesday. We should be able to know when the Deputy President is able to come and defend himself. I thank you.
Counsel for the National Assembly.
Mr. Speaker, sir, permit me to start by registering our greatest sympathies and empathies and from the team, the National Assembly. Of course, issues to do with health are issues that are beyond our control. Mr. Speaker, sir, that said, we also would want to be cognizant of the fact that we are dealing with a constitutional moment. We are dealing with an item whose timelines are prescribed within our Constitution. Mr. Speaker, sir, contrary to what learned senior counsel, Mr. Paul Mwite, would want to persuade this House to believe, the proceedings before this House have not been the subject or have not been transacted pursuant to Article 145(6). Mr. Speaker, sir, on the 9th of October this year, this House did pass a resolution pursuant to the provisions of Article 145(3). Mr. Speaker, sir, pursuant to that resolution, there was a Gazette notice which very clearly indicates that this House was not going to determine that the matter at hand from a committee perspective, but that the whole House would then be determining the matter. It then follows, Mr. Speaker, sir, that the provisions of Article 145(6) would not be applicable. Mr. Speaker, sir, in the same Gazette notice, you did gazette the 16th and 17th of October to and determination of the motion that is before you. That said, Mr. Speaker, sir, we appreciate the place of fair hearing and an opportunity to be accorded the chance and the facilities to be able to defend one's self in a motion such as this. Mr. Speaker, I would want to add that the opportunity to be heard does not have to be oral. The rules of this House permit that parties appearing could elect to be represented, they could elect to come in person, they could file documents. Mr. Speaker, sir, His Excellency the Deputy President has participated robustly in the proceedings both before the National Assembly, where they filed a very, very detailed replying affidavit and a response. Mr. Speaker, sir, if my memory serves me right, let me just make a quick reference. Before the National Assembly, His Excellency the President did file a response dated the 8th of October 2024. When the proceedings before this House began, His Excellency the President, the Deputy President again filed a very robust response dated the 12th of October 2024. Mr. Speaker, sir, up to this point, Excellency, the Deputy President, together with his team, have had a beautiful opportunity to present their case. They have had an opportunity to cross-examine in great detail all the witnesses that we presented before this House. If anything, Mr. Speaker, sir, if any prejudice were to be occasioned in the course of this, hearing this matter, that prejudice would be on us, because our expectation would be that His Excellency Deputy President would be able to attend and avail an opportunity for the National Assembly to cross-examine him. Mr. Speaker, sir, taking into account the circumstances that we find ourselves in, having also very keenly heard learned senior counsel speak, matters held are not matters to be taken lightly. On the same tone, Mr. Speaker, sir, matters held cannot be given timelines. There cannot be certainty that if an adjournment were to be given even for 1 week, then there is clarity and certainty in day. Mr. Speaker, sir, we would urge that we borrow practice that has accorded to other similar organs created by the Constitution. I have the courts of law in mind. Mr. Speaker, sir, because I earlier on submitted that Article 50 provides for an opportunity, provides for the right to fair hearing, and that fair hearing does not necessarily have to be oral, we have had practice in our Supreme Court. We are dealing with some of the most important decisions of our lifetimes, including decisions arising from presidential elections, have in all the elections that we have had parties file submissions and their documents, and that their advocates have had an opportunity to appear before the courts to highlight the pleadings that have been filed. In this occasion, because His Excellency the Deputy President has had an opportunity to present all the material that he ought to or he wanted to present, and also had the opportunity to cross-examine all the witnesses that he wanted to cross-examine, all that is left on the side is highlighting. On our part, Mr. Speaker, sir, the part of a full decision to forego the cross-examination of His Excellency the Deputy President and only proceed with highlighting submissions in relation to the documents that we have filed before this House. It is our humble view that no prejudice would have been occasioned to His Excellency the Deputy President. Mr. Speaker, sir, we urge that if I had my learned senior colleague, Mr. Paul Mwite, Senior Counsel, well, he seemed to have been imploring this House to consider adjourning. Mr. Speaker, sir, let me end by drawing the attention of this court to Rule 12 of the proceedings, the rules governing the proceedings currently underway. Mr. Speaker, sir, Rule 12 of those rules dictates that once the hearing has commenced, it shall proceed up to the end. It does not provide for an option for the House to adjourn. If that is the dictate, Mr. Speaker, sir, of the rules governing the proceedings before this House, we urge that being a country, being that is controlled by the rule of law and the Constitution, you direct that we proceed with the hearing as had been planned. I am most obliged. Mr. Speaker, sir, just before I leave the ground, maybe I would want to invite my leader, Mr. Honorable James Orengo, Senior Counsel, to also just add one word before you give your directions. I'm most obliged.
Mr. Speaker, just briefly. Mr. Speaker, just briefly. In these proceedings, we are governed by Article 145, and there is a very unique provision in Article 145 that you don't find in legislations to do with even litigation in the courts. But because the makers of this constitution knew that these proceedings are time-bound, there is under Article 145, sub-article 5, a very important provision. And I think that article is not there for cosmetic value. That article is there to deal with a situation like we find ourselves in, because the makers of this constitution knew that when processes are time-bound, they must be a safety valve. Article 145, sub-article 5, which applies mutatis mutandis in relation to the removal from office by way of impeachment of the deputy president, states as follows. The president, and for that matter, it should be read, the deputy president, shall they have the right to appear and be represented before the special committee during its investigation. Now, the point that I want to make, that not in a lot of legislation you find the right to be represented highlighted, because the deputy president can elect to be represented either by his advocate or by him appearing in person, or having both the deputy president and his advocate to appear. Now, I want to put before the Senate, because a lot of you have this problem a lot of time during the elections. If, in accordance with the election law, you are required to subscribe your nomination papers on a certain day, and you fail it, you're running for president or deputy president, and you're told that you must present your nomination papers on a certain day, as it is there in the law, would you feign sickness and fail to represent your nomination papers on that particular day? And I can tell you, if you fail to do so, the law will not give you any accommodation. You'll be out, and there are a lot of decisions on this matter. I want to talk to this Senate very frankly, that Senior Counsel Mwite was basically giving evidence. He has not told us where, or if he has told us, the medical institution where the deputy president is. But for the deputy president to fail to bring evidence, credible evidence before the House, that he's been admitted, even that evidence that has been admitted to a medical institution, we don't have it. We will rely on the evidence from my senior counsel, Paul Mwite. That is evidence. But in practice, I can say without a fear of contradiction, there are many times where people are represented even in medical documents, and later on they've been found to be fake, if I may use that word. I think the thing that the deputy president should have done, we should have had one of the doctors here, at least to tell us about his admission and about his condition, because up to 1:15 the deputy president was here. He was not evacuated from here in an ambulance. And if I can give evidence from the bar, he went to his office, and again there's no evidence that he was evacuated in an ambulance. He went to Karen Hospital in himself to check at the hospital. So I think our constitutional duty is to live by what the Constitution requires of us. The greatest prejudice, for me, I was looking forward to cross-examine the deputy president. But unfortunately, the story that has been told does not include cross-examination of the evidence of the deputy president, which is on record. But because we are time-bound, and as my London friend Eric Gumba said, we are prepared to go by the evidence in record. The prejudice is to us as more, because we would want to cross-examine him. but he has evidence in record which we cannot test by the way of cross-examination. And there's no assurance that on Tuesday, the Deputy President would be here. Finally, we can also say from here that there are many cases that have been filed all over, including in Malindi today, that has to do with the proceedings that are going on here. So I am in a position to say that this health condition in which the Deputy President is, and I sympathize, may be opportunistic in the absence of medical evidence from a doctor. It may be opportunistic. And I saw him when he came in. I'm not a doctor, but there was nothing to suggest that he was in the condition that Honorable Counsel has been talking about. So do the senators now turn into a jury to make a decision on the basis of evidence presented from the bar by senior counsel without no documentary proof